Hey, everybody. Just reminding everyone that for the first 5 minutes, we stay on mute as everybody joins. We have a large crowd coming in, I can tell already. So just hang on till about 5 minutes after and we'll get started. All right, folks, everybody's still joining. We're going to go ahead and get started. Welcome to April. My name is John Humphrey. I'm co-chairman of the Tort Claimants Committee. And we have a lot to do tonight. We've got a number of people that Doug will introduce. But first, I just want to lay the ground rules for what we're doing here today. Our job is to get you updated on what has happened in the bankruptcy case. As you recall, we've been through the bankruptcy Judge Silverstein affirming the plan. Doug and I were up in Delaware in the federal district court. We just heard from them a few short weeks ago. And so everybody's kind of wondering what's next. So that's what we're going to cover. Also, you know that we don't provide legal advice in these particular meetings. We would encourage you to talk to your counsel. And we're hopefully going to give you a roadmap of what the bankruptcy process looks like from here, how the plan gets confirmed, and how it goes effective. What's the appeals process at the federal district court? When will we have an effective date? What happens then? There's a stay motion that's out there, so we will get some update there. We'd also like to introduce you to Honorable Judge Hauser, who will be the trustee of the trust. As you guys recall, this is like a multi-billion-dollar startup, so there's lots to do, and we're very excited to have her with you. And she's gonna take some questions from Doug and I, and then Rich and David Moulton will be taking questions as well. So with that, I'm going to turn it over to Doug and let him introduce our guests.
Sure. Thanks, John, and happy April, everybody. One other thing I want to mention as well is that we're going to be going over a lot of detail tonight, and this is going to at times sound like a law class, I think. So the reason I bring this up is because this Zoom town hall will be recorded. It's getting recorded now, and we will be posting it to the website, and all that information will be on a slide at the end of this. So if any of this starts to go over your head, and trust me, some of it will, you'll be able to go back and refer to it. As John mentioned, we're very fortunate tonight. We've have all the plan supporters are together at this point, and we also are making headway on establishing the trust. So as John mentioned, the Honorable Judge Hauser will be with us this evening, and we've got some questions for her. As well, David Moulton, who is the counsel to the Coalition for Abused Scouts for Justice, is with us. Rich Pacholski, one of the counsels to the Tort Claimants Committee, is with us as well. So we've got a number of people that are going to be with us. Thanks to all of them for taking time to be here tonight. And we're going to jump right in and start asking some questions.
Yeah, thanks, Doug. And remember, tccbsa.com. We'll mention it again at the end, but if you have to drop for any reason, the recording will be there and updates will be there. So I guess my first question will be for Richard, but before I ask it, I just want to thank David Moulton and his team, the Boy Scouts and their team, and Richard Pacholski and his team. We're in year 3, and there's been a lot of heavy lifting, and people have worked hard, compromised, and we've gotten this plan before us, and so we're very excited about where we are in the process. We're not done. As you remember in our first town hall, I believe Jim Stang said all that survivors really want to know is how much are they going to get and when. And so we're still not there yet. So there's still a lot to do. So Richard, what has happened since Judge Silverstein approved the plan? How did we get here, and what's next?
Thanks so much, John. Great being able to participate today, and I'm excited because I think we're hopefully in the home stretch of starting a process that will start getting the survivors the compensation they deserve. So let me set the table this way, John, just because it's going to set some context as to some of the other questions I suspect you or Doug are going to have. So the plan of reorganization was approved by the Bankruptcy Court. There was originally an opinion that Judge Silverstein had entered, and ultimately on September 8th, 2022, the Bankruptcy Court entered the confirmation order approving the plan. But that was the beginning of the process in some respects, because on September 22nd, 2022, 17 insurers and frankly 2 groups of survivors appealed the Bankruptcy Court's confirmation order to the district court. And there was a briefing schedule that was set by the district court, and there were very extensive briefings in that respect. And the district court held 2 days of oral argument on February 9th and February 10th, 2023. And listened to all of the parties, both supporting the plan and opposing the plan. And fortunately, and in many respects sooner than some of us thought, the district court affirmed the confirmation order, meaning that the district court found appropriate all provisions of the plan and entered that affirmance on March 28th, 2023, John. So that kind of set the wheels in motion of what we're now going to go and describe to those participating on today's webinar.
So David, one of the questions that we have gotten from survivors several times in the past, when the plan was approved, the survivors said, okay, it's approved, now what? And then Judge Silverstein approved the plan, and then survivors said, okay, so now let's move on. So my question to you then is, can you explain what the significance is of the district court now approving the plan?
Yeah, thank you, Doug. And before I answer that question, I just want to thank everybody out there. It's been a long ride, a difficult ride, but as I told a bunch of people a week ago, we're very close. One of the things that those of you who sat through the district court argument, I think it was 2 days of full argument, you saw an engaged federal district judge. ask very difficult questions, and not, those difficult questions weren't only aimed at the objectors, but they were aimed at the plan supporters as well. And so lots of people left there, oh my God, what's going to happen? Are we going to get this, order, the Judge Silverstein's confirmation order affirmed? Is there going to be any issues with it? If you would ask me what we got a week ago Monday, we got 100 out of 100. It was an unbelievable, comprehensive, thorough decision by Judge Andrews that really makes, to the extent, there will be a further appeal to the Third Circuit, and we'll talk about that, makes that just a lot easier. The district court approved the confirmation order, simply put, from top to bottom, without any exceptions. All of the settlements approved by the bankruptcy court were upheld. And that includes the BSA settlement, the local council settlement, the United Methodist settlements, the insurance settlements with Hartford, Century, Zurich, and Clarendon. Also, the settlement trust, the procedures that govern the settlement trust, and the trust distribution procedures, the procedures by which you all out there will get paid, and which a lot of time and effort of everybody, survivors, their state court lawyers, the bankruptcy professionals, and experts were directed to. These were all approved without modification. And the assignment of the insurance rights, again, an extremely important part of this plan, for the independent review option, as well as augmenting the $2.5 billion we already have in there, was approved. So we are in terrific shape, given to us in a beautiful opinion crafted by Judge Andrews. You guys saw the length. I mean, it's this thick, and it really puts us in a wonderful place in terms of getting this thing wrapped up and finished. Thank you.
Appreciate it, David. Thank you for that thorough answer. Sorry for my little I knocked my camera off the top. You just can't do live television without something going on. So Richard, question for you is, what needs to happen for the plan to go effective? And that, I think that word means a lot more to lawyers than it does to survivors. So maybe you can unpack that a little bit.
Yeah, let me try to do that. And I agree with what David just said. I mean, we're excited because Judge Andrews affirmed everything. And I think that is going to help us go through this process. We'll explain that all in a few moments, what that means going forward. But one of the technical issues that we all have to deal with is that a plan effectively can't be implemented until it goes effective. It's a term of art, but effectively there's a date by which the plan is cannot really go forward, or at least the provisions of the plan, unless the plan is deemed to go effective. So the question is, in most bankruptcy cases, the plan can go effective after the bankruptcy court has issued its confirmation order, and there's no stay of that order. And that happened on September 8th, 2022. So then the obvious question is, why didn't we just try to go effective on September 8th, 2022? And the reason was really simple. For a variety of technical reasons that really aren't worth going into at this point, the plan not only required the bankruptcy court to issue and enter the confirmation order, but it also required the district court to effectively approve of that confirmation order, which is what happened on March 28th. So this case was somewhat different. It's a complicated mass tort case, and that's what required it to some degree. And now we're at that point. So what does that effectively mean? For the trustee, who has really been very thoughtful and monitoring what's going on and trying to move the process forward, as well as the claims administrators, really didn't have funding to move forward. And even if there was funding, you still couldn't go effective. It just meant that you would have been able to set up the mechanism to ultimately go effective and start the process. As soon as the district court affirmed, the various parties, the BSA, the TCC, the coalition, and in particular the settlement trustee, went ahead and said, we need to be ready to go effective. And in that respect, there's been an incredible amount of work to try to get the documentation in place, bank accounts opened, and the other necessary acts so that ultimately the cash and other assets that are coming into the settlement trust can be held for the benefit of the survivors. Now, I want to kind of use an analogy. It can be either a home or an investment, but you can't just kind of snap your fingers and go effective and start the settlement trust. There's a huge amount of work that goes into the process of creating a trust, such as the accounts, such as the execution of a variety of documents, and frankly, the process of transferring approximately, as David said, about $2.5 billion in cash and other assets in the settlement trust. So we believe that whatever the effective date is, and our hope, and we're going to work hard to do it, but there's never a guarantee, is that sometime around mid-April we hit the effective date. But we're going to get into at some point why that becomes somewhat complicated. But I do want to make something clear, because I know there'll be obvious questions. Is okay, the trust is set up, isn't that great? Now we can move forward. But the problem is, or in some respects, the opportunity is to move the process forward so that the settlement trust, that's when you really cut through it, an over $2 billion business where we hope other money will come in. One of the reasons the insurers have fought this process is because there's 17 who have not settled, and we hope to get money from those parties. But we do have to set up the infrastructure to make sure that the survivors get their money as quickly as reasonably possible, but in a thoughtful way. And that is what the trustee, the claims administrators, and other parties, as that I've described, are working on, so that we can be up and running as of the effective date. And that, as much as we would like to say that's the closing of the process, to be very frank, in many respects, it's the beginning of the process, analogizing it to buying a home and either buying land or a home you remodel. That's what we're doing now, and we want to make it as perfect as possible under the circumstances. So that, John, is basically where we are with respect to the settlement trust, and that we're working hard to be able to go effective and do the work that we've been waiting to do for many, many months now.
Thanks, Rich. David, do you want to make any comments related to what Rich has said in this timetable for this going effective?
Yeah, I'll just give, I'll briefly give some dates as to the timetable, and then I'll follow up, I think, a little later with the scheduling. The district court's approval or affirmance of the confirmation order, as you heard, was entered on March 28th, a week ago Monday. The district court's orders automatically stayed pursuant to the provisions of the plan 14 days, as well as the bankruptcy rules, through April 11th. So as a result, and we'll get to other issues that may delay effective date a little longer, the plan cannot go effective until April 12th, which is a week from tomorrow at the earliest.
Great.
Thanks.
So Richard, what prevents it from going effective?
So David is correct. If everything in a perfect world, we would go effective on April 12th. So what is the problem? The problem is that we have the 17 insurance companies and the 2 survivor groups who have now appealed the confirmation order, and the appeal is effectively going to go to the Third Circuit Court of Appeals, but that doesn't mean we can't go effective. The appeal in and of itself does not do it, does not stay the effectiveness. But what the parties have also done who oppose what we've been trying to achieve is they've gone to the district court to ask for a stay so that the district court affirmance will not go into effect, and that we still cannot go forward and start getting and really push forward with the settlement trust. The briefing is scheduled for this week on that stay. only Judge Andrews knows what he's going to do with that. We hope that there will be a very quick decision, and we're very hopeful that Judge Andrews will not grant the stay. But even if Judge Andrews, who now has the matter at the district court level, does not grant a stay, then I have no doubt and that the 17 insurance companies and the 2 survivor groups will then seek a stay with the Third Circuit Court of Appeals. Again, we're hopeful that the Third Circuit will see that both Judge Silverstein and Judge Andrews were very thoughtful and very lengthy, detailed opinions, that there will not be a stay. We hope that those 2 stays will be denied by April 12th, and we will then go effective. If not, we will push forward to get the process moving. Again, 2 courts have to make a decision by April 12th to hit that date, but if it's a week later, it's a week later. Our hope is that that does not happen, but we want to do whatever is necessary, and we're going to battle to make sure that we hit that effective date and that we hit it sooner than later, and that hopefully the stays are not granted so that we can all move forward together and come up with a successful resolution of this case.
Rich, I think that's a really good overview. David, is there anything else related to those specific dates that, you know, survivors look forward to this? Sometimes it's easy to say, okay, well, April 12th, then things will be effective. But obviously there's some other things that could happen in the meantime, could happen in addition to this. And one of the comments we've talked about for a long time is often this is like playing 3-dimensional chess. So what's the other dimension here that's going on at the same time?
Yeah, let me give you my view of it and some prognostications from this pretty weathered bankruptcy and trial lawyer as to what we're going to see and when. I'll caveat that I've got a better sense from in terms of the district court than I do from the circuit. But as Richard said, on March 31st, the insurers, as you know, filed their emergency motion to stay the district court's affirmance until the Court of Appeals, the Third Circuit, ruled on their appeal. The DNV and Lujan appellants filed, I think, a day later, April 1st, April Fool's Day. And the judge ordered today, the judge actually issued an order, Judge Andrews, we're talking the district judge, that kind of, from my sense and my experience, gives me an ability to a little bit of prognostication, Doug. And that's, he ordered that the debtor and the plan supporters' responses be filed on Thursday, April 6th, which is in 2 days. And I know we're hard at work on that right now. Everybody out there should realize that our sleeves are rolled up, and we're going to have a terrific set of papers filed on there. He then gave the objectors 1 day to file a reply. And he said, I don't need any replies. He said, if you want to file a reply, you can file it, but I don't need it. April 7th, this Friday, I think it's Good Friday, April 7th. He also issued another part of that order, and he said, I'm denying the effort by certain of the objectors to submit oversized briefs. So he doesn't want to read more than he has to. From my experience, I'm going to say that means this judge, who wrote a 100+ page thorough decision, completely dealing with every one of these issues, is done with this case, and he's ready to give it up. And if you're asking me, I would expect that sometime soon after Friday, April 7th, and I don't know how soon, but it's not going to be weeks, folks, and it may be just days. You will see, you will not see, my view, a formal written decision denying the stay. You'll see a 1-pager that says the objector's motion to stay the appeal, to stay the effective date pending Third Circuit review is denied. Denied. That's what you're gonna, that's my view. I may be wrong. As I say, that and a dime doesn't buy you a phone call or a cup of coffee anywhere in the country. But that's my experience, and I'm giving you the benefit of my experience. There will not be oral argument, by the way, on this. So the judge is getting the papers and he's ready to rule as soon as he gets the papers. You don't have to call everybody back to Delaware and hear them jump up to the rostrum and talk. So that's where we are. But once that stay is denied by the district court, if it's denied, and it's going to be my view that it will be denied, it may still stay the order of effectiveness for a shorter period of time. And that's going to be up to the discretion of the district judge. So the appellants can go up to that district court's boss, which is the Third Circuit Court of Appeals, and seek a stay pending full review to the Court of Appeals. And if that's the case, and if they do move for a stay to the Court of Appeals, that will be done arguably on an expedited basis, but we don't know what the timing and the briefing schedule will look like there. But that's what it looks like. So we're all crossing our fingers that by the end of this week or the beginning of next week, we're going to be through the first phase of the stay application being resolved in the favor of survivors. Thank you, Doug.
Thanks, David.
So that's our optimistic view. And having sat and listened to the judge, honestly, in the 2-day argument, that he was all over the details. So but I have to give the counterpoint, David, because survivors sometimes are disappointed. So Rich, what happens if it gets stayed?
So John, that's a very, very fair question. And it's been something that has been on David's and my and Judge Hauser's mind and others, the claims administrators, the lawyers, our colleagues at David's firm and my firm, as to what to do. And this is an issue we thought about in terms of what we didn't even, in fairness, we tried to get ahead of the issue even before thinking about what happens if the district court or Third Circuit stays. As I mentioned initially, John, some of us, including myself, I'm probably not always as optimistic as David is, but I absolutely think David is right about his assessment with respect to what Judge Andrews would do with the stay. But I was worried that it would take Judge Andrews longer to come up with a decision than it actually took. It was very thoughtful, and it was done in a much shorter period of time. And so Judge Hauser and David and I had been spending some time to think about, well, how can we move this process along, even before thinking about the stay, just so that we're prepared to be up and running at the time that the effective date hits. And so starting particularly at the beginning of the year, we started a dialogue with the Boy Scouts to try to put together funding to not go effective, but to have the trust up and running. And we took a little time, and we were able to negotiate what we call the advance funding motion. And that advance funding motion was filed on March 1st, 2023, in which the Boy Scouts and the coalition, the TCC, the FCR, all filed the motion in support. Now, initially, the motion was scheduled to be heard on March 23rd, but the Bankruptcy Court moved it to April 19th. And obviously, the decision came down 5 days after the original date to be heard, the advance funding motion. Not unsuspected, the 17 insurance companies and the 2 survivor groups opposed the motion. They're seeking whatever delay they could. I frankly think it's unfair vis-a-vis their opposition, because the whole point of the trust funding motion was to allow the Judge Hauser to basically do over a little more runway based on what we thought the time would take for Judge Andrews to open bank accounts, to interview and hire professionals, to start, for instance, developing the questionnaire process, and so that the trust was farther along when hopefully the plan was ultimately confirmed and not stayed, or so it was affirmed by the district court and not stayed. And so that was the goal of that motion. Now, if we go effective on April 12th or sometime reasonably thereafter, that motion will effectively not be necessary. But as John said, we're always cautious. And at this point, we intend to move forward on April 19th, even if the district court does not, even if the district court goes ahead as David hopes, and I hope, and Judge Hauser and the other parties who've been dealing with this, that Judge Anderson does not grant the stay. But we don't know what the Third Circuit will do. And in light of that, we're going to move forward basically on a parallel path. One is to get ready, assuming we hit an effective date soon, hopefully during the month of April. And one, if we don't hit the effective date, because there is a stay, so that the settlement trust can be formed as far along as possible before that stay is lifted, assuming a stay went into effect. And but we're cautiously optimistic that and hopeful that that motion will not happen. But if it does, we hope that it gets approved and that we'll be doing a lot of the same work going forward that we are doing right now to get ready for the effective date. So that's the goal, John, is that we're basically have a plan A, which is go effective immediately, and a plan B, if it's stayed, that we can start preparing the settlement trust to go into effect.
Well, thanks, Richard and David. Great answers, very thorough. I'm sure many people, including myself, are going to have to go back and review the video to take some notes. So with that, Doug, I'd like to turn it over to you.
Yeah, thanks, John. And it's my great pleasure to introduce Judge Barbara Hauser into this process. And I think it's important for survivors to understand that the way the plan is set up is that the bankruptcy court sort of gets itself out of the business, and Judge Hauser will be the trustee for the survivor's trust. And I've been trying to think of an analogy today to sort of explain how this works, but essentially it's if 82,000 people are the owners of a business and Judge Hauser is the CEO. She's been hired to run this business and a multi-billion-dollar business and figure out how to run it effectively, efficiently. And we are so lucky to have her be the person that's going to be at the helm. So I think the first and most important thing, Judge Hauser, is for you to please tell us about your background and some of your experience and you know what brought you to this point.
Thank you, Doug. I really appreciate the opportunity to speak with the survivors of the abuse in the Boy Scout cases. To give you a little bit of my background, I grew up in a small town, kind of in the middle of nowhere in Nebraska. Was fortunate enough to decide upon a career in the law and have enjoyed my legal practice for about 45 years. I was in private practice in Dallas for 22 years before I took the federal bankruptcy bench. During the course of my 22-year career, I was a corporate bankruptcy lawyer. I did this kind of work. I represented debtors, creditors committee predominantly, and really enjoyed my private practice years. I was fortunate enough to develop a national reputation as a bankruptcy lawyer and concluded my career as a lawyer handling as lead debtors counsel the Dow Corning bankruptcy case, which at the time was one of the largest mass tort bankruptcies in the United States and world, and was a challenge that I worked on for a number of years before it was successfully concluded. And shortly after that plan went effective, I had been selected to take the bench in Dallas in the Northern District of Texas. So I have experience in the handling of mass tort cases from the debtor side, from the creditors committee side. And you know, it's a very, very challenging area of the law, but one that is truly fascinating. I took the bench in January of 2000, and presided as a bankruptcy judge, as I've mentioned, for 22 years. During those 22 years, I had the opportunity to handle a large volume of cases. The Northern District of Texas, at the time I took the bench, was a quite busy court. We had a lot of Chapter 11 and other cases pending before me. I think during the highest volume year, I had some 8,000 cases assigned to me individually as a bankruptcy judge. So it was a very difficult docket to manage, but one that I found extraordinarily fulfilling. During the course of the time that I served as a federal bankruptcy judge, I was very active within the federal judiciary. I had the opportunity to do a number of things within the bankruptcy community and within the federal judiciary community, which made my time as a federal judge extraordinarily rewarding. One opportunity that came my way, perhaps it was a phone call I should have declined, but about 4.5 years before I finally retired from the bench, I got a phone call and was asked if I would consider leading a federal judge team to mediate the issues in dispute and the debt restructure for Puerto Rico. Puerto Rico had a number of instrumentalities that filed a bankruptcy-like process under a special statute that Congress enacted that enabled a territory of the United States to file for bankruptcy. So while municipalities under the current bankruptcy code can file for bankruptcy, such as Detroit as a good example, a territory or a state of the United States is prohibited from filing bankruptcy under the bankruptcy code. Because Puerto Rico had such a massive debt problem and the parties had been unable to resolve that debt outside of a formal court process, Congress enacted a special statute called PROMESA that permitted Puerto Rico and 7 of its affiliates, other instrumentalities of Puerto Rico, to file a proceeding under Title III of PROMESA, which was essentially a mix between Chapter 9, the municipal bankruptcy case, and a Chapter 11, a corporate reorganization case. I led a team of 5 federal judges, myself, another bankruptcy judge, Judge Tom Ambro from the Third Circuit Court of Appeals, and 2 federal district judges. And we worked for 4.5 years to help Puerto Rico restructure its debt, which totaled some $120 billion. It was an extraordinarily difficult assignment that I undertook. But it was one that was extremely rewarding because of the complexity of the project and the fact that there were many, many complications, including hurricanes, earthquakes, political unrest that resulted in the resignation of a governor. I think there was a 3-day period during the Puerto Rico proceedings where we had 4 governors in 3 days. Which made the case and our mediation efforts a bit challenging. But thankfully, with a lot of hard work and cooperation from the parties, we were able to restructure all of the debt. That was a real credit to everyone who was actively involved in the process. So once I thought Puerto Rico was wrapped up, I decided it was time for me to embark on the 3rd chapter of my professional career. So on January 20th of 2022, January 20th of last year, I officially retired from the bench. Although I think many people think it was kind of a fake retirement because I immediately embarked upon a number of other projects as part of Chapter 3. I am currently serving as the future claims representative in an asbestos case pending in the Southern District of Texas, and of course was proposed to be the settlement trustee here in the Boy Scout case. As we all know, Judge Silverstein approved my appointment, but my appointment doesn't take effect technically until the effective date of the plan. And so we have been waiting for the opportunity to try and take the trust effective. And as Richard and David have explained, we are close to a date where we think that can occur. So there's been a lot of things that I've done over the course of the last 45 years. Each phase as a practicing lawyer, as a federal judge, and now embarking in these fiduciary roles have been extremely rewarding. And I'm looking forward to going to work for the settlement trust and for the benefit of the beneficiaries of that trust, which of course is the constituency that's listening in this evening.
Thank
Well,
you.
we certainly appreciate you taking the time out of your busy schedule to be with us. And, survivors have been anxiously awaiting who this person was that was going to be the ultimate arbiter of their fate. But maybe you could, I don't want to put you on the spot, but what is it about your background and the things that you've done that makes you the right person to serve as a settlement trustee, if you don't mind?
Maybe I should ask you guys that. Why did you pick me? I'm happy to try and answer that question. I do think that, as I mentioned earlier, I grew up in the Midwest. And I don't know what your experience with Midwesterners are, but my perspective is that we have a work ethic that may be replicated in other parts of the country, but probably not surpassed in other parts of the country. So I have been a very hard worker my entire career. I have said often that, I'm modestly smart, but you work hard to find somebody who's willing to put in more time and energy and effort to get to a good result, or as good a result as is possible. So I think my background and my work ethic is something that makes me particularly well suited for what will be a difficult project here. I also think that the time that I spent on the bench also provides me with great background and experience to take on this role. When you're a bankruptcy judge for 22 years, handling thousands of cases per year, which means tens of thousands, if not hundreds of thousands of claimants whose claims I have to oversee as a judge and allow. I think that makes me particularly well suited to look at these claims with the assistance of my claims administrators and really decide how best to deal with them. I have always been a good manager of processes, and I think that's a key component of this role, is to manage these processes as effectively and as efficiently as possible. I think the time that I have spent as a judicial mediator during the last 45 years has also made me empathetic to the competing considerations that parties have, the pressures that people are under, the opportunities that creates, but also the disappointments that creates. I tend to be a pretty empathetic person. And so I think if you combine all of those things together, it's at least my hope that I will be well qualified and do a good job here in getting this trust up and running and managing this process and trying to bring the process to conclusion as quickly as possible, which means, of course, making distributions to claimants whose claims have been approved.
Thank you.
Judge Hauser, so you're about to embark on managing a trust that deals with the adult survivors of sexual abuse. And I think one of the questions that we hear all the time from survivors is, how well will the trust understand us and what we've been through? So I think that's a fair question. And that is, how has your experience in the past sort of helped to inform you? And what's the trust going to do to make sure that it understands this unique population?
Well, I think a couple of things, Doug. First, we intend to interview and hire a sexual abuse consultant, someone who has worked with survivors of sexual abuse in the past and who is intimately familiar with the issues that we will face in addressing these kinds of claims. So I think that will be an important first step. I have a lot to learn. I will be the first to admit that. But that is something that I welcome and will put my energies into developing a good understanding of that. The best news there is that in addition to the sexual abuse consultant that the trust will hire, is that the survivor consulting group selected two excellent claims administrators. One will oversee the trust distribution process. The other will oversee the independent review process, although they will be working together and working with me. Both of those claims administrators, Randy Roth and Judge Michael Reagan, have experience in dealing with sexual abuse claims. And I think their experience in the past and the expertise that they also contribute to this process will be of enormous benefit to us. But I think we're all here to say that we need to learn about our survivors here and the claims that they have. But we're embracing that, and we'll do the best we can to learn as much as we can, just as quickly as possible.
Right. And I should mention too that I don't think I'm talking out of school. I think that we have hopes to get Ms. Roth and Judge Reagan on one of these meetings sometime soon as well.
Absolutely.
So in addition to those two, what are some of the other things you guys are doing in the interim waiting for the plan to go effective? I'm sure there's a long checklist.
There is indeed a long checklist. So the day that we got word that Judge Andrews had affirmed the bankruptcy judge's decision, I immediately sent a note out to debtors counsel, next steps, where are we? No point in letting any grass grow. And we got on a phone call with all of the interested parties on the supporters of the plan side of the equation and mapped out what our game plan would be, all the steps that would need to be taken in order to take the plan effective. Needless to say, we've been extremely busy for the last 8 days in finalizing the documents that will have to be signed by me as settlement trustee on behalf of the trust, working to get those documents in form that we think are appropriate and protect the rights of the beneficiaries of the trust. We are in the process of, we've sent out a request for proposal in order to begin to interview claims processing firms. As you all know, better than I perhaps, some 82,000 claimants have filed claims in this case, and we will have to have a firm that is experienced in the handling of that data to work with us in the evaluation of the claims so that we can determine what claims will be allowed and at what values those claims will be allowed. We are in the process of interviewing, or will be in the process soon of interviewing those parties in hopes that we can actually have not only the documents ready to go by April 11th, but we can have, if we're fortunate, we can have a claims processing firm selected. So all of the things that will go into actually being able to take the trust effective have to be done. We have to set up bank accounts. As you all know, there's a lot involved even in that simple task of setting up the bank accounts, hiring a financial advisor to help us manage the 700-ish million that will come into those bank accounts on the effective date. So there is a lot of work that has to be done in order to interview, tentatively hire, and then ultimately hire all of the professionals that I will need to work with in order to ensure that we can manage this process as effectively and again, as efficiently and as fairly as possible.
Judge Hauser, a lot of our questions get back to something John talked about earlier, and that is survivors always ask, how much am I going to get and when am I going to get it? And one of the things that this relates to is part of the trust distribution procedures is this questionnaire. And a lot of survivors thought the claim form was essentially the questionnaire, but what has to be developed is a very robust questionnaire that will help to inform your people as to what those awards should be. So I guess that question then gets back to how much time. So what's involved in developing that questionnaire, and what should survivors expect from a time standpoint of when that's going to be ready and they should be thinking about completing that?
Well, those are all difficult questions, Doug, to answer, but let me take my best stab at that. Part of the reason why I think several of us were in favor of the advance funding motion that was finally filed on March 1st was because we were in a bit of a limbo period where we didn't have a decision quite yet from Judge Andrews. And there was so much work that needed to be done in order to be in a position to easily transition to an effective date for this trust. For better or for worse, the motion didn't get filed because we didn't have consensus on it until it was filed on March 1st. But the whole theory of that motion was to enable the two claims administrators and myself to have sufficient funding that we could hire the claims processing firm. We could begin to build the public-facing website that will be important for the trust to have so that the claimants can log in and look and see for updates and other things. So there's a lot of mechanical things that will have to go on before we can actually really formally begin work. What we find ourselves in now, at least theoretically, assuming the plan can go effective before the April 19th hearing on that advanced funding motion, is a situation where what could have been done over a several-month period in a very thoughtful and logical way, we're now doing in a thoughtful way, but we're doing it much more expeditiously. So it's really kind of everybody's hunkered down, all hands on deck, and we're moving very, very quickly because we feel the need to in order to be in a position legally to take the plan effective as quickly as we can. But what that means is that the work that we thought we would have the opportunity to do before the effective date to make the transition smoother is now going to have to be done after the effective date. So we have several months of work, and I wish I could be more precise, but I really can't be. We have several months of work that will have to be done. The questionnaire will take time to develop. And in a bankruptcy case, a bankruptcy proof of claim is not required by law or the bankruptcy rules to be overly robust. Congress envisioned that claims should be able to be asserted in a bankruptcy case relatively easily because many creditors in bankruptcy cases may not have their own personal counsel. They may be representing themselves, and therefore a really cumbersome or tedious claim form is something that it was concluded wasn't required in order to make your claim of record. But in order to implement this plan with the very detailed trust distribution procedures that we'll be working with, we need more information from the claimants. So one of the first things that I think the members of the staff and the two claims administrators and I will be working on is to develop a questionnaire. I can't tell you if that's a week process, a month process, but we will be working on it very diligently to think through with the claims processing firm the kinds of information we need from the claimants in order to be able to process these claims in an efficient way. And so that will take time to develop. That will then get sent out to claimants. And of course, in fairness, they have to be given a reasonable amount of time to respond and get the information back to the trust, who will then have to input that information into the claims processing database so that the processors of those claims can actually begin to work. Because sexual abuse claims are unique, many of these claims processing firms cut their teeth, for lack of a better word, in the asbestos arena. And an asbestos claim is just very different from a sexual abuse claim. So the claims processors, the men and women who will physically take the first look at those claims, need to be trained about sexual abuse. And so there will be a significant amount of energy that is put into training of the processors who will do the first look at these claims in order to begin that process. So as Rich said earlier, in a corporate context, I'm the new CEO of a $2.5 billion startup company. I wish I could tell the survivors that it's like flipping a switch. We just turn the lights on and we're ready to roll. It's not that simple. But I will tell them this. You have my commitment, and I know you have the commitment of my two new colleagues, Judge Michael Reagan and Randy Roth, that we will work as hard as it's possible to work to get this trust up and running, to get the claims processing process moving forward, and then to begin the evaluation of claims as quickly as it's possible to do. What's critical to me, and I think one of the reasons I was selected, is because I am a neutral here in the sense that I'm not beholden to any particular constituency. My job is to be a fiduciary to my beneficiaries, the survivors of the Boy Scout sexual abuse. And we will do that, and we will do it to the best of our ability, but we will balance the need for speed with the need for thoughtful, empathetic dealings with our survivor community.
Thank you so much.
Really appreciate that. So the bad news, I guess, for survivors is we need to remain patient and give the trust time to get all of its people and processes and technology in place. And I would say that the good news from what I'm hearing is that the intent that the TCC and the coalition had in the trust distribution procedures is that they would be robust and they would be in a high level of integrity and very solid. So given that, what can survivors be doing today? They've submitted claims form. Most are represented, some are not represented. What advice would you give them today regarding additional information for the questionnaire?
Well, I think the best thing you can do right now, whether you're represented by counsel or not, is to collect any additional information that may not have been part of your original proof of claim filing, so that you have the data together, so that when the questionnaire does reach you, you can fill it out, you can provide as much information as possible, and then return that claim form as promptly as possible. Because as soon as we start getting those questionnaires back, we will start inputting that data, which will allow us to begin to review those claims. So I think that using this time to good advantage in the collection of the data, I think would be incredibly helpful. And so I think that's the most important thing. The second thing I will say is I ask you to be just a little more patient. I understand that you've been waiting a really long time. My heart breaks for the amount of time that has passed and the abuse that you suffered. It's heartbreaking. It's nothing short of heartbreaking. But what I ask you to keep in mind as it relates to the trust and the work that I will be undertaking with my two claims administrators is we haven't been involved in this bankruptcy case for the last 3 years. We have just now gotten involved, and it will take us a little bit of time to get the trust ready to really be in a position to move forward with the actual processing of claims. So I know you've been patient in the past. I know this has drug on too long. I know that money may not be an adequate compensation for the experience and the trauma that you have suffered. But I do ask you to be a little patient with us, because I do, as I have already promised you, I mean it when I say we will be working as hard as we know how to work. But it's going to take more time than I would like. And I certainly know it's going to take more time than you would like. So be as patient as you can be and get that documentation together.
So I guess the next question then is, what happens in the interim if, when the plan goes effective, the 9 of us on the TCC are out of work, so to speak, our volunteer work comes to an end. And what will the trust be doing to sort of keep up with that communication, not just with survivors directly that have attorneys, but particularly those survivors that are representing themselves? How will that communication, how will we be able to keep that linkage with survivors now?
Well, you all may go away, as you've said, Doug, but now it's my job. It's my job to keep the survivor community informed as to what's happening. So we will have a public-facing website that will be up and running just as soon as possible following the effective date. You will be able to submit information requests to us through that public-facing website. The two claims administrators and I will have email addresses that will be published on the website so that you can send us questions if you have them. We will also publish frequently asked questions. There will be frequently asked questions and the answers to those questions that will be available on the website that will keep you informed as to process and the questions that we know you likely will have that we can answer in that fashion. But the public-facing website, we hope, will be in a position to let you track actually yourself the status of the claim that you have submitted. So we will be doing everything that we can to keep you informed as to the process. The trust agreement itself has certain requirements that I have to comply with, including annual reports, reporting to the court and to the survivor community, the beneficiaries of the trust, our progress. How many claims have we processed? How have we disposed of them? And the like. And of course, we will timely file all of those. And lastly, it is my intention that we will have periodic town halls where my claims administrators and I can provide updates, just as we're doing tonight, on where we are, what we've been doing, what we've accomplished, what we're still working on and have yet to accomplish. So understand that this is going to be a multifaceted process. While we've got a very important job, obviously, with the claims, my job, in addition to assisting in the overseeing of the claims, is to manage all of the other assets that the trust will be getting. As I believe the survivor community understands, we get cash, but we also get litigation claims. We get some artwork, we get some real estate, we get some oil and gas properties, and all of those hard assets that aren't cash will have to be converted into cash. And part of my job will be to hire the right people to work with me to market those assets and to try and liquidate them, to build up even more cash reserves within the trust that we'll then use to distribute to claimants when we are able to begin the distribution process itself. So it'll stop being the job of the TCC and the coalition per se to keep the survivor community informed, but it will become my job. And that's something that will be really important to me, is to keep the community involved and informed about what we're doing.
Well, thank you so much. Yeah, John,
Yeah.
go ahead, but Judge Hauser, thank you.
Yeah.
My pleasure.
What a great town hall. Special thanks to Richard Pscholsky, David Moulton for all the work that your teams have been doing. And a special thank you to Judge Barbara Hauser. I think I speak for Doug, the committee, the members of the coalition, when we say you will be in good hands. And you've got a real pro there, high degree of integrity and a whole lot of experience and the knowledge of how to bring people together. So with that, folks, I think we're going to wrap it up. Remember, www.tccbsa.com and scoutingabusesurvivors.com. If you have questions, these two email addresses below, tccquestions@pszjlaw.com and bsacoalition@brownrudnick.com. So as we close, hang in there, take care of each other, take care of your family, and with all Godspeed, we will be on to the next phase of this process. So
Stay
thanks,
strong.
everybody, and good night.
Stay strong, everybody.